Protecting Your Contract Receivables, PA Mechanics Lien Law, and Payment Bond Claims was a live webinar that was originally produced on Thursday, November 9th, 2017. For this webinar, we were joined by attorney Tom Williams from Rager and Adler PC and our very own Mike Hoffner. We hope you enjoyed this webinar recap, and please visit us online at www.macpas.com for more information about our future webinars and other events.
Well, good afternoon. My name is Dan Matarisi, and I'm a Senior Manager here at McConnell & Asbury. Thanks for joining us for today's webinar, Protecting Your Contract Receivables, PA Mechanics Lien Law, and Payment Bond Claims. So today we are excited to have Tom Williams here from Rager and Adler PC, as well as our own Mike Hoffner, and I'm confident that we're going to have some good conversation around some important concepts. If anyone has any questions for our speakers, we encourage you to submit them through the built-in questions function, and we will do our best to answer them either during the presentation or at the end of the webinar. So thanks again for joining us today. And with that said, Tom, why don't you go ahead and get us started?
Well, thank you, Dan, and good afternoon, everybody. I'm happy to be presenting my portion of this important seminar. A little bit about my background, not too much time taken here, but I've been practicing for approximately 26 years, and most of my practice revolves around representing folks in the construction industry. And major issues in construction industry revolve around collecting your payables. So when I was thinking about coming up with a title of my portion of the presentation, I come to this slide name, which is, when it comes to protecting your receivables, be a smarty and don't be tardy. Again, old receivables definitely do not get better with age. I think probably most people know that, but at the time when I get to meet with clients that are having problems with invoice payment, this is the biggest reason for not getting paid, is letting them get old, those invoices. And again, just to reinforce the point, old wine, yes, you want that to get old, but you do not want your receivables to grow old in any way. They get old and moldy, and nothing good happens from receivables getting old. Now, time flies when you're seeking payment from customers. A couple of things you certainly have control of, and a few things you don't have control of. The folks that owe you money are controlling when they pay you, and to the greatest extent that you can avoid your customer having control over when you get payments, the better. And a couple of things that I note certainly on this slide is delays. You're part of your own problem if you are delaying in creating your own invoices and submitting those invoices to your customers. So obviously the first point at which you can avoid delays is having a very strong and consistent billing process and a particular person who is responsible for getting those invoices out in a timely manner. Next, contract payment terms oftentimes have built-in payment delays. You may be signing contracts that have provisions in there that say, well, you'll get paid when we get paid, or you'll get paid if we get paid. Certainly you're taking on a lot of risk there. But even over and above that, a lot of times they have, your right to receive payment is timed in a number of days, like 30 days from receipt of your invoice, or 90 days. So that's something that you have control over, and something certainly you're going to want to be proactive at in reviewing contracts, particularly the payment terms, so that you make sure that that's a reasonable turnaround time for you. I would note that oftentimes, at least in the construction industry, you are working with form contracts that have been pre-negotiated, I'll say, for example, the AIA family of documents or the consensus docs. They have payment terms in there, and they are usually deemed to be fair, in terms of the turnaround time. What is not in your control is when you start finally identifying that you're behind on receiving your payment from your customer. You start getting maybe excuses, then you start getting stiff arms, and then you get radio silence. That's not a good thing. And then even after maybe even you've been forced to file some kind of action, some kind of litigation or something, that might be the first time when you actually receive some kind of response from your customer saying, not that cash flow is a problem like he was saying before in the excuse portion here, but now, oh, we don't think you did all the work properly, or there's a problem, there's a defect in the work, and that's why we're holding your payment. So again, the more communication early on, the better, and enough said about that. So what to do when payment is late? I'm an attorney, so what I would suggest first is that you contact experienced counsel sooner rather than later. Why do I say that? Not only because you'll have an ally with you, but more importantly, at least in the construction industry and some other industries as well, but in particular, construction industry have specific remedies that have to be exercised within a certain number of days. So you never want to go to your lawyer's office the day after your rights to file that action has run. So get to your counsel early on so that you can be educated as to when you need to move. Where do your remedies come from in the event that you haven't been paid? Well, many of your remedies will be in the contract itself. Some of your remedies are set forth in statutes. For example, mechanics liens and payment bonds, which we'll talk about, as well as prompt payment laws. Those give you remedies as well. And then finally, under the common law. Common law is essentially judge-made law. It's comprised of precedents and reported cases from courts. And finally, there are some remedies that are termed equitable remedies. For example, you may have been familiar with a cause of action or a remedy entitled unjust enrichment. That's something that your counsel can certainly assert in the event that you don't have a written contract or an oral contract. The courts have allowed equitable remedies such as unjust enrichment to the extent that somebody has received a benefit from you and has not paid for it. The court will infer an obligation on that party to pay. Now, again, there's a question at the bottom. Are there dispute resolution processes required in my contract? Yes, oftentimes, again, in particular in the construction industry, there will be set forth in the contract itself what kind of remedies are available, number one. And number two, where do you go to resolve that payment issue? Can you go directly to court? Must you first stop at a mediation, perhaps? Or must you arbitrate your dispute? That's something that, whether you have a project manager who's responsible for reviewing contracts or whoever it might be, you need to identify early on what happens if we have a dispute on this contract. Where do we go? Because you don't want to file a lawsuit, for example, if your contract requires that you resolve your remedy or resolve your dispute in arbitration, because the courts will enforce that, and you'll go back to square one and you'll have spent money needlessly. Now, mechanics lien, we'll talk about that first as one of your statutory rights. What is a mechanics lien? Well, basically just boiled down, it's a claim securing a priority for payment. Much like a mortgage would be, you can kind of liken it to a mortgage in that it's a lien on the property, and it's provided to contractors for value of labor and materials that they've provided to a property, a project. and the lien is against the land and building. Now we have this concept, there's a couple of Latin words here at this last bullet point, in rem versus in personam. The action for mechanics lien is referred to as an action in rem. It's an action against the property. So it goes against the property when the lien is recorded. It is not a judgment against the person who owes you the money or the company that owes you the money. So that's something to keep in mind. That's a distinction. It's not like a breach of contract action would be the action against the party, the named party that owes you the money, not the property that you provided the material to. Again, the mechanics lien is an in rem action. It goes against the property. Now, the mechanics lien law is intended to protect the prepayment of labor and materials that a contractor invests in another's property by allowing the contractor to obtain a lien interest in the property involved. It's a very powerful tool to have. Folks generally don't like to have liens put on their property, so it's quite a stick to have available to you when you are owed money. And again, it may not, in many cases, it may not be asserted against the party that owes you money. It's against the owner's property. So if you, as a subcontractor, for example, are owed money, putting a lien on the owner's property, you'll have an instant ally in your corner. That owner will most definitely be in contact with the contractor that failed to pay you to, let's say, encourage them to pay you. Now, a mechanics lien is only one of many potential remedies for non-payment. I want to make that clear. You have several remedies available to you if you happen to be a contractor or subcontractor that's not been paid. You'll have, for example, breach of contract action. You'll have potentially a surety bond action, and you may also have an action to assert a mechanics lien claim. So these are not exclusive remedies, and keep that in mind that you may have more than one avenue to seek payment. Now, again, as defined before, a mechanics lien is placed for the improvement of property. It includes any building, structure, or other improvement erected or constructed on land, together with the fixtures and other personal property used in equipping it for the purpose for which it was intended. Now, you can't put a mechanics lien on just any property upon which you've provided material or labor. A mechanics lien is only available on private projects, privately owned property. It is not available for a project, for example, for a school district, or if you do a DGS project, you may not lien publicly owned property. Next, you might ask, well, am I a proper claimant to be able to file a mechanics lien claim? Well, you can be a contractor. In other words, you could have a contract directly with the owner of the project, or you could be a subcontractor, or you could be a subcontractor, having a contract with a subcontractor, or you can be a supplier. Any of those types of entities or people that are standing in that position can be a potential claimant. Now, who may not be included, or what may not be included? What can you not get if you are filing a mechanics lien claim? Well, you're only really going to be able to be paid the value of the labor and materials you provided. You may not get, for a mechanics lien claim action, attorney's fees, interest, or costs not related to the improvement. Again, this is unlike a breach of contract action or a different kind of lawsuit filed which may also include a prompt payment claim, where you may be entitled to recover attorney's fees and interest. But again, speaking strictly about the mechanics lien claim, all you will be entitled to recover is the value of the labor and materials provided. Now, one of the reasons why I said you need to seek an attorney promptly is because of this slide. Filing and perfecting a mechanics lien. The mechanics lien statute, as it is in virtually every state, I believe every single state has a mechanics lien law, and they are all different. They require, well, you have to comply with the statute strictly. You cannot miss any steps or not comply or fail to comply with any of the requirements. If you do, your lien is subject to dismissal. So it's very important that you have somebody that knows what they're doing here, so that you don't fall through the cracks here or fall into any of these pitfalls that may be awaiting you on seeking this remedy. Notice requirements. For example, if you are a subcontractor, for example, you do not have a contract with the project owner, you must first submit and serve a notice on the project owner 30 days prior to filing your lien claim. Okay, that is to give notice to the owner that, hey, I'm out here, your contractor failed to pay me, so your property may be subject to a lien. The statute requires that subcontractors and suppliers provide that 30 days advance notice. Now, you might say, well, I could do that. That's not a big deal. I can give a notice to the owner, but again, there's a specific section in the statute that governs precisely what has to be contained in that notice. So whereas you think that you could craft such a notice yourself, which will basically put the owner on notice, if it does not have all of these items in the letter, again, it is subject to dismissal. We can go through this list very quickly. You'll have to put your name as the claimant, the name of the person with whom you contracted, the amount of the claim due, the nature of the kind of work you did. You can't just say, I was on your project. You have to say, for example, I did the plumbing to include piping and fittings and balancing and things of that nature. A description of the property. You have to identify the property, at least by address, not necessarily at this point by legal description. The other important thing to keep in mind is a lot of folks, when they are doing work on a project, they know the property kind of through a common name. Or that's Joe's Garage, or that's the ABC company's shoe store or whatever. You need to make sure before you send this notice that you have the actual record owner of the property. You cannot send it to somebody who you believe to be the owner. If you have to literally find the present owner on the deed. You need to, I highly recommend that you get a current deed so that you can identify correctly the record owner of the property. It may be some holding company that you have no idea, had really no involvement in the project. But if you don't send the notice to the properly identified and named record owner of the property, it's all for naught. You're going to get that dismissed. Filing deadlines. Okay. You have 6 months after the completion of your work to file a mechanics lien claim. Please note That's not 6 months from when you submitted your invoice or 6 months after they failed to pay you. That is 6 months after you finished your work. That's when the clock starts. So it's very important that you get the bills out timely. You know, how long is 6 months? You might say, well, that's, my gosh, I've got a lot of time. Well, let's just assume for the moment that you don't even through your office get bills out until maybe 2 months after you finish your work, right? So now you're down to 4 months. And just keep in mind now, as we just went over, if you're a subcontractor, you have to serve the owner 30 days prior to the 6 months deadline with your notice of intent to file a lien. So really your deadline in affirmative action you must take to perfect your lien is 5 months from the date of completion of your work. So again, if you are delaying putting your invoices together, you're doing so at your own detriment, certainly, and you've already substantially eaten into that time frame. You know, and then let's say you get the invoices out within a month or two. Then if they're not paid, they're probably not late for another 30 days, right? And then after that, if you've got somebody responsible for bird dogging down these bad receivables, you're going to start making some calls to the customer, and the customer may answer you, may not. He may say, oh, I'll get to you, you know, don't worry about it. I'll pay you in a couple of weeks. And then a couple of weeks goes by. You have to call again. And then, you know, at that point, if he goes radio silent, you're pretty much running up against your 5 months to get that noticed out. So again, 6 months might sound like a fairly long time, but you have to control that clock. All right, under section 1503 of the statute, now if you've successfully given notice as a subcontractor, and keep in mind as a contractor, if you have a contract directly with the owner, you don't have this notice prerequisite, but the claim itself, once you are at the point where you're ready to file the mechanics lien claim itself, there is another section in the statute which states specifically what information has to be in that mechanics lien claim. So you can see that there are at least 8 items specifically that have to be set forth in this mechanics lien claim. If it's not, it's subject to dismissal. Now, waiver of lien rights. The mechanics lien law has been around for decades, and for many decades it was not. It did not see any amendment. But in recent years, we've had kind of a flurry of changes to the mechanics lien law. One of them being a few years ago, where the legislature passed an amendment to the mechanics lien law that made it unlawful and against public policy in a contract for somebody to require you to waive your right to file a mechanics lien claim. That's applicable to commercial projects only. In a non-commercial situation, you could still have a situation where you are waiving your right. So that's important to note. If you see a contract come down the pike that seeks to have you waive your right to file a mechanics lien, that's not enforceable unless a payment bond has been provided by the contractor. Under that scenario, if a payment bond is put up for the benefit of subcontractors and suppliers, then and only then can there be a valid enforceable waiver of lien rights. Now, perfecting your mechanics lien claim. Number one, you need to serve the mechanics lien claim on the owner within 30 days of filing the claim. Okay. Then you must file proof of service of the lien claim within 20 days of the service. Missing either of these timelines by a day will result likely in the dismissal of your mechanics lien claim. Again, this is a strictly enforced statute. Contesting a mechanics lien claim. Again, once you file the lien, it is subject to possible dismissal in any number of ways. Number one, this rule to file a lien is something that it's a mechanism that a lawyer can use to basically make you put up or shut up. You cannot just sit on your rights to file a lien. At that point, essentially the rule will be, if you believe you have a right to file a mechanics lien, you must file it within 30 days. Preliminary objections is a pleading that's filed in response to the mechanics lien claim. The preliminary objections will set forth, basically any defect in the process you used in filing the lien or in the lien itself. Again, if it doesn't comply strictly with the requirements of the statute, it will be subject to one of these preliminary objections. The owner's counsel will be searching through what you did with a fine-tooth comb to make sure that you ticked all the boxes, so to speak, and there's no way to get that lien kicked out. Finally, there's a mechanism called bonding off the lien. That's what's commonly referred to as bonding off the lien. An owner may have that mechanics lien discharged by either himself or having another party basically place in court a bond in twice the amount of the lien itself. That bond will stand instead of the mechanics lien, and that will be the security. That's used in order, if somebody needs to get, for example, refinancing or a mortgage of that property, they certainly don't want to have, and certainly the lender doesn't want to have the mechanics lien sitting out there as a prior claim. So that's a mechanism that's used in that circumstance. Again, these preliminary objections might be asserted on a number of bases. Number one, it might be an exempt property. You may have attempted to put a lien on a publicly owned piece of property. That would be exempt. Your lien will be dismissed by the court. Perhaps you're not within the class of people that are permitted to file a mechanics lien claim. There was a lawful and enforceable waiver of liens. We just went over that. If there was a proper bond provided and there is a lien waiver that you've agreed to, that will be enough to likely have the lien dismissed. And the catch-all here, the last one, is that you failed to somehow comply strictly with the statute. Now, a discharge of the lien, any party can request discharge of the lien where a sum equal to the lien or double in the form of a surety bond is deposited. Just reiterating there that some parties actually, if they can't get a surety bond, they might actually put cash up. And in that case, you only have to put one time the lien to get it discharged. Now, we've gone over a lot about mechanics liens claims, and just when you thought you had it all down, there's more stuff now to remember, okay? More recently, the legislature passed another amendment which has brought up a whole different, I'll say a whole new process kind of that's been kind of just attached to the mechanics lien statute, which changes the way folks deal with their mechanics lien rights and with owner and contractor obligations. And we'll get into that right now. The change is known as the State Construction Notices Directory. Again, it's a new concept, a new process that everybody working on a construction project needs to know and ultimately needs to comply with. Now, why did the Pennsylvania legislature add the directory to the Mechanics Lien Law? And is this change unique to Pennsylvania? I can tell you that the Pennsylvania legislature adopted, not wholesale, but in large part, a statute, this kind of procedure that was already in law in Utah, actually. And there's a similar provision in New Jersey and some other states. So it is not unique to Pennsylvania. It has been adopted in some form by several different states. Now, why did this come about? Well, many project owners had experienced mechanics liens being put on their project or put on their property when they didn't even know the claimants were working on their property. This certainly would happen in a circumstance if there was a subcontractor. Owners typically do not know. They may know who their contractor has hired to do work, but they probably would not know who those subcontractors may have engaged to do work on your property. So this directory was intended to avoid that situation, surprise liens, if you will. And under this whole directory situation, you've got owner requirements, contractor requirements, and subcontractor requirements. Each of these parties ultimately need to interface with the directory. Owners need to file what is referred to as notices of commencement. Subcontractors are required to file notices of furnishing. And we'll go through what these particular notices are. The contractor requirements are to place a notice of the project on the directory for the owner. Again, owners may only have one project in their whole lifetime, whether that's an entity or individuals. But contractors are more likely to be up to speed on this, and owners will many times defer to their contractor to make sure that their project is identified on the directory and having the contractor file on the directory the notice of commencement. There are also a few optional filings which we won't get into. There's notice of completion and notice of non-payment. They really do not have any bearing on the effectiveness of a mechanics lien or the rights for a unpaid subcontractor to file a lien. Important, the timing for filing on the directory. An owner must file a notice of commencement prior to the commencement of labor, work, or the furnishing of materials on a searchable project. A subcontractor must provide its notice of furnishing within 45 days after first performing his work on the job site or providing materials, if you're a supplier, to the job site. You might ask, do I need to enter information on the directory for all of my projects? The answer is no. This directory is only required, your interface with this directory is only required in the event that the project is what is called a searchable project. Searchable project is defined in the statute as new construction or alteration projects costing more than $1.5 million. Okay, so projects over $1.5 million are subject to this directory requirement. Where can you find the directory? Actually, you can find it at the website that's on here, or by accessing it through the DGS website. I found that link to be very effective or very clear and folks that I've talked to have accessed and used it have commented that it's pretty user-friendly and easy to deal with. You would go onto the DGS website, and there are links at the bottom of the landing page called public links, and that's how you gain entry into the DGS directory. Now, you might ask, why am I accessing the DGS directory? That's a public entity. Well, when that's a fair question. When the legislature enacted this amendment, they provided requirements for somebody to build out this directory, and they had to find somebody to do it. So they said, DGS does construction stuff, so we'll put it in their agency. We'll require them to build this out. And over about a year and a half's time, through assistance of meetings with stakeholders and all, DGS, along with its hired folks, they hired some different companies to help build out this system, and they did that in about a year and a half. Now, do I have to pay to use the directory? Only the owner has to pay. It's a $72 one-time fee. The owner pays the fee to get the project, the searchable project, up by filing a notice of commencement. Subcontractors and suppliers that file their notices of furnishing, or they just want to maybe research on the directory, or they just want to receive notices from the directory, they're not required to pay any fee. Serious slide here, consequences of not filing notices. Okay, so if you're an owner, there's absolutely no requirement that you file a notice of commencement. However, if you as the owner don't file a notice of commencement, the requirement for subcontractors and sub-subcontractors is not triggered because there's no searchable project. So what the net result will be that you'll remain in the dark as to potential claimants. So it's only to the benefit of the owner to file. As for subcontractors, if the subcontractor fails to timely file on the directory a notice of furnishing, very simply, they will forfeit their right to file a mechanics lien claim. I do have a note here that neither the owner nor the contractor may attempt to dissuade subcontractors and suppliers from filing a notice of furnishing to get them to waive their rights, essentially. They can't threaten them and they can't mislead them. That's actually covered in the statute. There are specific penalties if that happens. Additional requirements. The owner must conspicuously post a copy of the notice of commencement at the project site. What does conspicuous mean? Well, that's not defined in the Act, but generally speaking, I would say if there's a job trailer where other job-related information is provided on the project, that is someplace where you would want to post very conspicuously this notice of commencement. If there is no such trailer, perhaps putting a very large stake in the ground with with this notice posted on it in a place where it might have the entryway to the project, that would probably suffice. It must be posted before physical construction begins. If I'm a subcontractor and I want to find out if this is a searchable project so that I have to file a notice of my furnishing, how do I know this? Well, you can ask the owner, you can ask the contractor, you can review your contract because the contract is obligated to have a reference to the fact that this is a searchable project. You can look for the notice we just talked about posted on the project, or you can simply, if you have a login on the directory, you can simply access that directory and do your own research and look up the project by county, the owner name, or the address, or if somebody on the project gave you a project number, you can look it up that way. Important to note, these new requirements, the amendments that provide for the notice of commencement and notice of furnishing required in the directory, they do not affect or do away in any way with the existing subcontractor notice requirements for properly perfecting your mechanics lien. So in other words, it does not do away with the prerequisite notice that you must provide to the owner. It is in addition to. So don't think that this amendment does away with that. It does not. So another question. How many ways can I mess this up? It's not hard to be in a position where your lien rights are waived or they're attacked in some way, as we've just gone over the last several slides. So it's something to make sure that you have conversations with the right professionals so that you don't mess it up. Because if you do mess it up, then you lose that very strong tool of a mechanics lien. Let's turn quickly now to another remedy, which is typically applicable to public projects that you are working on. Under a statute, the public projects require bonds. Many of you know there are performance bonds that protect the owner, and there are payment bonds that protect subcontractors and suppliers for payment. Contractors must furnish both bonds on public projects. There are federal projects, federal public projects, and state public projects. On the federal side, the surety requirements, the bond requirements are set forth in what is called the Miller Act. Each of the individual states, including Pennsylvania here, have what are referred to Little Miller Acts, which essentially mirror the requirements of the Miller Act. The Little Miller Act in Pennsylvania is also referred to as the Public Works Contractor Bond Law. It covers projects over $5,000. That's a pretty small project. If you get below $5,000 on a public project, that's pretty darn small. So essentially, all public projects that you work on are going to have a payment bond that you may access for payment. Who is protected by bonds? Subcontractors, sub-subcontractors, and suppliers. All of these folks are going to have claimant status under a bond action. Similarly, or similar to the mechanics lien law, if you are a claimant seeking recovery through a payment bond action against a surety, you also are responsible for meeting certain notice requirements. If you are a claimant that does not have a contract with the contractor who provided the payment bond, in other words, if you are a sub to a sub, you must provide written notice to the contractor within 90 days from the date of last work or the last day your materials were supplied. We suggest that notice is to be sent by registered or certified mail, and we would also suggest that you send a copy to the owner and the bonding company as well. Again, if you just send it to the contractor in compliance with the law, that contractor may bury that information. What you want to do is get the surety's attention. and the owner's attention. The last thing you want to hear from the owner in asserting any of these rights is, if you're a subcontractor that's due money, the last thing you want to hear is, oh, I just paid the contractor the balance of the contract yesterday, thereby not having any leverage with the owner. If the owner is withholding money, obviously he's got a mechanism to force the contractor to pay you. If all payment is gone, then that remedy is going to be less effective. So one of the morals of this story that we've been talking about is, again, turn over all the stones for potential payment remedies. In that regard, I have seen an increase in private project owners in requiring their contractors to put up payment bonds, because a couple of reasons. One of them, they want protection. They want to make sure that, and they want to make sure that subcontractors that gave value to their property are paid. So always check on this possible remedy that a private project owner may have required the contractor to put up a payment bond. Just do not assume, since it's a private project, that there can't be this possibility of going on a payment bond. Statute of limitations for a bond claim is 1 year. Okay, that's in the statute. It's 1 year from the date of providing the last of your work, and again, 1 year goes very quickly. The courts have opined, however, that your action on a payment bond as a subcontractor does not actually accrue until you haven't been paid for 90 days after you finished your work. So what that comes down to is essentially you have a year plus 3 months. But I never advise clients to go right up against a statute. It's very dangerous territory. So I always tell my clients it's a year from when you last did your work. If, for example, they happen to come into my office in 13 or 14 months, and we can use the benefit of this 90-day period in which the statute's essentially told, TOLLED, then so be it. But I do not advise clients to proceed in collecting or asserting rights right up against the time deadline. Nothing good happens from that. Okay, the extent of the surety's liability. Again, the what you can get as a claimant is limited. The surety is not liable to pay for lost profits, negligence damages, attorney's fees, or delay damages. You may seek those remedies through a breach of contract action, which is wholly separate from an action against the surety. But keep in mind that the surety, similar to a mechanics lien claim, the surety is only going to be responsible to pay for your labor and materials that you provide. I usually close my presentations with what I call our golden nuggets. There is no way that you're going to remember everything that we've covered. So I like to have what is called golden nuggets, just something for you to remember. First one there is ride herd on accounts receivable. You need to have people responsible for timely preparing and sending out invoices, and to follow up on those invoices if they're not paid on the day they're supposed to. Next, note the critical dates for statutes of limitations. Help your counsel out. Know the dates that you last did work on a job, because he or she is going to ask you that right out of the block to make sure that we've met the statute. Obtain copies of all bonds. just because you're asking for a payment bond, the other party might say, well, you're highly litigious, you're anticipating suing me, blah, blah, blah. Well, the fact is, better to identify that there is a bond and get a copy of the bond when there is no dispute, as opposed to when there is a payment issue, there may be some inherent reluctance to provide you with a copy, at least swiftly. And do not attempt to assert claims without assistance from experienced counsel. As a lawyer, I don't try to build things. I don't try to do plumbing. I don't try to do electrical work. So the same would apply for all those folks in the trades. That would be all of you guys out there that I have the greatest and utmost respect for. Your skills in performing those kinds of work, I would never try to do that, and I would just say, don't try to do self-help with these remedies, because the likelihood is that you're going to mess it up, just as I would trying to do plumbing. At this point, I'd like to turn over to Mike to do his portion, and then we look forward to, hopefully, if time permits, answering some questions. So Mike, take it away.
Thanks, Tom. I appreciate it. And certainly a tremendous amount of information there, but I think your last bullet point is the one that I would say is most critical in my mind, is that folks should call you. Tremendous amount of things to consider and to remember, and it's not something that the common person, whether they be a contractor or an accountant, should be messing with. So I appreciate that, and invite all the folks who are listening today to keep in mind how to get a hold of Tom. We're going to take our last 10 minutes here and talk a little bit about the financial reporting implications of some of the things that Tom's talked about. Obviously, the focus on cash flow is the most important part of this, and ensuring that we've secured our ability to get payment. But there are some things we need to think through in terms of how we account for and report and communicate to the stakeholders in the organization potentially delinquent receivables and at-risk receivables. So we're going to talk just for a minute about why it matters. We're going to touch a little bit on the accounting rules and how to think through some of these, and how some of what Tom has talked about needs to be factored into that discussion, and then the actual discussion through some of the other areas in your financial statements that may be impacted by some of these discussions. So first and foremost, why does it matter? Obviously, good fiscal planning. We've all been we're far too recently through some tough times in the construction industry. We know that cash forecasting is difficult as it is, and when we have lack of clarity on when we're going to get payment, let alone if we're going to get payment from owners or prime contractors, it just adds more complexities to how we run our business and how we manage our business. So that's the obvious piece. Second, I think we need to make sure that the users of our financial statements have visibility into the things that are at risk. Obviously, some of our users get external financial statements, so a full set of financial statements with footnotes. They go to banks, they go to bonding agents. Those are the items that receive a high degree of scrutiny from those who are helping us run our business and helping us finance our business. And we need to be really clear with those folks when we have at-risk receivables and when we have concerns about when and if we're going to get paid, not because they want to be punitive, but to discuss those things on the front end is a far better answer than having to explain to a lender why you were too optimistic in the analysis of some of your receivables. And then finally, we need to talk in our world about the rules and how to make some of these assessments. It's great to talk about delinquent payment or threats of non-payment or just silence and the radio silence as Tom addressed, but we also have to filter it through what the accounting rules say, allow us to come to a decision on whether we should reserve or not reserve a receivable. So the words I want you to remember, and I'm not going to spend a tremendous amount of time on this particular topic, but the words I want you to remember are probable and reasonably estimable. Those are the words that drive whether we reserve a receivable on the financial statements, and that's not just for external reporting, that's for internal as well. And so we need to think through each of these receivables when we have a claim, when we have a customer or a contractor who's not paying. We need to filter whether our financial statements should reflect that $20,000 invoice or should reflect that as a reserved against invoice. So the word probable in this sense means it is a likelihood of occurrence, a high likelihood. It's not sometimes we hear in the tax world, we hear 51% threshold gets to a probable determination. And in this sense, it is not a 51% more likely than not kind of assessment. It really is a high likelihood. So, well, it's not a black and white. Probable is the thing we need to think through in terms of some of the lien rights that Tom has talked about, and whether placing those lien claims or filing would put us into a position where we might conclude that collection of a receivable is probable. So bear in mind, as Tom said, the mechanics lien will be to secure your labor and materials costs by placing a security or rights against the property, and that may or may not be the party that owes you the money. It's not a straightforward discussion of I have a receivable that I'm not getting paid on, and so I go ahead and I file a claim, and therefore I'm going to get paid. It's not that simple. It's a greater discussion than that, but it certainly is, as Tom said, a high degree of leverage against the individual or the organization that owes you the money if you have the property owner in your back pocket saying, look, you need to pay them. This lien needs to come off my property. The other thing to bear in mind as we filter through this, it's not always about the gross amount of your receivables. So when we're thinking about this idea of a probable collection or a probable loss, and if I've concluded that I may have a probable loss, we also need to think about the reasonably estimable part. How much am I going to collect? So when we talk about lien rights maybe securing your labor and materials, we have to factor that against the consideration is that $20,000 receivable that I'm chasing. Perhaps I have lien rights, perhaps I can go after a portion of that, and so I can conclude that maybe some of it's collectible. But reality is, as Tom had said, it is not a pursuit of payment like you would need to go through other means to get from the actual the organization that owes you the money. It's just it's a method to try and wield the big stick to get your payment. So as we think through these ideas of probable and reasonably estimable, we have to come to a conclusion. If we believe that we're not going to collect and it's probable that we won't collect and we can estimate the amount of the receivable we won't collect, then absolutely we need to think through booking a receivable in our financial statements, both internal and external. And the rules do require, and there's a few points there on the slide about disclosures, when you're doing external financial statements, if you come to a conclusion that you don't believe a loss is probable, so in this case we've filed and secured our lien rights, we believe that's going to be enough of a implication on the owner that we're going to get paid, disclosure may still be relevant and it may still be appropriate. Again, we want to have these conversations with the stakeholders before it becomes a true loss situation. So the normal process, pretty straightforward, and I think those on the financial reporting side are aware of it. We evaluate specific at-risk receivables. We think about those cases where we may have a known fact that says we might not get paid, whether it's a straight-out refusal of payment, bankruptcy filing by the owner. We have some known issues with cash flow. If we get to that conclusion that we might not be paid, we think about whether we book a reserve. This whole hour of conversation on filing particular remedies and trying to protect your payment status adds a different layer to the discussion. So remembering when we file our claims and we file our lien rights, we have to think through, does that protect my receivable? I've had contractor clients tell me that, yeah, we're going to go ahead and reserve a balance. I have filed and verified, I've dotted all the I's, I've crossed all the T's, I am confident that I have rights and I will probably get paid. But it's going to be a drawn-out process. I'm really not sure how it's going to end up or where it's going to end up. So I'm going to go ahead and do a full reserve on that particular receivable. I've also had clients tell me that we absolutely will get paid. We filed a lien. We've had our conversations. I absolutely know that the owner's going to put pressure on the contractor and they're going to pay me as a sub, and then realize down the path that they didn't consult with somebody like Tom. They missed one of the I's, they missed one of the T's, and ended up having to write off that receivable down the road. So I wouldn't say, sitting in my shoes, that there's an absolute right answer. I think it's a process of thinking through, do the things that Tom has walked us through earlier give me a high degree of comfort that I will get paid? And second to that is, if I will get paid, how much will I get paid for the work that I've done? And ultimately, the outcome of that is a balance by balance assessment of what I need to report and record on my internal and external financial statements. So again, it's process, not a black and white answer. So finally, just a few other things to think about as we wrap up. Sometimes we work on a job and continue to work on a job when we're still working on that job, when we realize that we've now have an issue confronting us with an outstanding receivable. Don't forget, as we go through this process, to consider the unbilled side of what we've done, and consider the unbilled side as we think about financial statement presentation. If I have an unbilled receivable sitting on an asset side of my financials, and I've come to the conclusion that I likely have a loss in the billed side, I need to think through that to its conclusion and what that means to the unbilled and whether it truly represents a valid asset of my organization. Also seems obvious, don't overlook other projects that you may have going on with the same owner. If you file your rights against a particular property and you're doing work in other areas, the fact is you didn't get paid on project A is a strong indicator that you might not get paid on project B, and you need to be thinking through what your process is going to be and how quickly you're going to call Tom to make sure that you secure your rights for payment on the other projects you may be working on in that case. Finally, just as a wrap up, when there's potential cash flow concerns, again, all too recently we came out of a tough time in the economy. Contractors were struggling with cash flows. We need to be constantly reforecasting and thinking about how am I going to meet my current obligations? How am I going to meet my long-term obligations? How am I going to keep my lender and my bonding agent happy? Because ultimately, I need to continue my business as a going concern. So looking at potentially high-risk receivables in a vacuum and making sure I've filed my lien rights, I've filed all my potential remedies, I'm following all the rules, I'm doing what I need to. We can't take our eye off the fact that those potentially concerning cash flows might impact things in a greater way in the short term before we can actually collect that cash in the long term. So just something to think about as we go through. Ultimately, as Tom had said, it's the most important thing, first and foremost, is to step in and identify at an early stage when you might have a concern and when you might have a potential conflict in a receivable, and to make sure that you get your bills out timely, make sure that you get all of your follow-ups done timely, and make sure you understand the rules surrounding how to perfect those lien rights. So as we're out of time here, as it's 3 o'clock, I think we've hit our number just about right. I see we do have a few questions, but unfortunately, as we're out of time, we're not going to answer those live, but what we will do is, for those of you who ask the questions, we will follow up individually with you to make sure we get you the answer you need. I would also invite you to contact Tom on any direct questions you may have or concerns you may have regarding how to go through this process. And I invite your questions and conversations with me in terms of thinking through some of the financial reporting implications and how that might impact the way your stakeholders view the organization. So we appreciate your time. We appreciate your tentativeness. And Tom, I very much appreciate having the chance to do this with you today. And with that, I will turn it back over to Dan to wrap us up.
Thank you once again for joining us for this presentation produced by McConnelly & Asbury. We hope you join us for our upcoming events. You can stay up to date with news and learn more about our upcoming events by visiting www.macpas.com. Thanks again and have a great day.